Tyler Gobar. Mr. Gobar, you need to take your mic off of mute. Mr. Gobar, you need to take your mic off of mute.
Yes, sir.
Okay, now, Mr. Gobar, your case is set for arraignment. You're supposed to be here in court in person.
Yes, sir. I just got a word about it yesterday from my bail bondsman. I guess they just found out and they told me yesterday.
Okay, but who told you to appear via Zoom?
I called.
Okay, his thing is stuck right now. Mr. Gobar, can you hear me?
Yes, sir.
Okay, now, Mr. Gobar, we're getting ready to start arraignment.
Uh-huh.
You either need to sit in one spot, look like you are somewhere out in nature,
Hmm.
and so you need to sit in one spot, or you need to turn your video off, and then you can put your mic on mute as well, and you can listen into what's going on. But you need to, at the end of the arraignment, your case will be reset, and you need to appear in person.
Yes, sir. Yes, sir.
Okay,
Yes,
so
sir.
turn your mic off, mute, and turn your video off.
Okay. Yes, sir.
All right. Thank you. Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You've been asked to come to court today for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanor. Your felony cases are normally referred to as your more serious type of criminal offenses, whereas your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Now, if a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. Or if a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a capital murder, the range of punishment is, the minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case. It's not a felony case, so you don't have to worry about those type punishments. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor are cases that start in the city court or the JP court. They only come to this court if that person is found guilty or if they plead guilty no contest in that court, and then they appeal that case. In essence, they want a new trial. Then the case comes to this court, they get a whole new trial. And the range of punishment for a Class C misdemeanor is a fine only. You only can be given a fine. You can't be given jail time, and the fine cannot be above or cannot exceed $500. Now, just for an example, a Class C misdemeanor is not wearing your seatbelt, speeding, having an inspection sticker that it has expired. Those cases are considered Class C misdemeanors. Now, if the person does not pay the fine, or if the fine was converted to community service and it failed to perform the community service, then the court can issue what is called a capious pro fine. It's just basically mean it's a warrant for your arrest for you to either pay the fine, or if you do not pay the fine, you have to sit the time out in jail. And if you sit the time out in jail, you'll be credited at $100 per day for every day that you sit in jail. Now, the next highest misdemeanor is a Class B misdemeanor. And with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And with that type of probation, you will not have a conviction on your record. And if you successfully complete that probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. What a non-disclosure is, it basically means that your record, the record on that case, will be sealed to the general public. So the general public cannot have any access to it because it's sealed to the general public. Now, the operative word that I've used is general public. That simply means that the government, certain governmental agencies can have access, like the police department, for example. But most of the public is general public, so most of the public cannot have any access to it. So if you're working at, say, Exxon Mobil, and they tried to look it up yet, and you had a non-disclosure, they couldn't get into the record because it's sealed to them. They're not part of the government agencies that have access to it. Now, the other type of probation is called adjudicated probation. With adjudicated probation, it does result in a conviction on the record. However, there's something that is called judicial clemency. That means that the court or the judge can set your conviction aside, which means that you will no longer have a conviction. And in order to qualify for judicial clemency, three things has to happen. Number one, you have to successfully complete the probation. Number two, there cannot be any more time left on the probation. And number three, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the court has the discretion to set your conviction aside. You will no longer have a conviction. Now, however, if you get another conviction later on, we call that a subsequent conviction. If you get another conviction later on, then the case that you receive judicial clemency on can be resurrected, revived, brought back up, and it can be used against you. If you try to get a license with Child Protective Services, which is called CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. All right. Now, everyone here for a case should have a clipboard. I'm getting ready to go over that clipboard with you. Before you leave, let me see. Okay. We're gonna look at that. It's gonna, I guess it's the second page. It's not the little sharp page. It will be the it's that first long page. It's titled Judge's Explanation of Rights to Defendants Without Attorney. Now, before we leave, and that document looks like this. Okay. Before we leave, everybody is going to read. I'm going to go over this document, and you're going to make a choice at the bottom, one choice, and then you'll sign it there. All right. Now, this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first paragraph below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date to give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Okay? Now, but you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is on that clipboard. Now, before we do that, this is only for people who will be requesting a court-appointed attorney. You would have to fill out that 3-page document. The 3-page document is titled Affidavit of Indigence or Jefferson County Affidavit of Indigence. And for those of you who will be requesting a court-appointed attorney, you would have to fill out the first page of this document. And then on the second page where it says defendant oath at the top, you'll fill that out at the top, just this portion, where it says defendant's oath. And then in the middle of this document where it says near the bottom where it says unsworn declaration by defendant, you'll fill this out and then you'll stop. It's only for people who will be applying for a court-appointed attorney. So if you are requesting time to hire your own attorney, this is the only document that you have to read and sign. There's one document. If you will be applying for a court-appointed attorney, you'd have to sign this document and the Jefferson County Affidavit of Indigence. Now, that next paragraph, the third paragraph says that you may not speak to a prosecutor unless you first sign a waiver of your right to be represented by an attorney. That paragraph is referring to people who will be representing themselves. Okay. If you represent yourself, that means that you are your own lawyer. Just like the lawyer can talk to the assistant district attorneys that we call prosecutors, you will have the same right. Why? Because you're your own attorney. You're representing yourself. And so you can talk to them about your case. But you may not talk to them. That paragraph is saying you may not talk to them about your case unless you first sign a waiver of your right to be represented by an attorney. A waiver of your right basically saying that you have a right to have an attorney. However, you're waiving or giving up that right and you would like to represent yourself. So the waiver is a 1-page document that is also on the clipboard, and this is only for people who will be representing themselves. You would sign this, read and sign this document. And then once you do that, you'll have an opportunity to talk to the prosecutors about your case to see if you can work out maybe what we call a plea bargain. A plea bargain means that it's an agreement to settle your case. That's what a plea bargain is. All right. Now, for those individuals who will be waiving their right to an attorney and representing themselves, this paragraph that's in block form, it states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last paragraph states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you decided that you wanted to represent yourself. And then let's say that, well, you'll talk to the prosecutor to see if you can work out a plea bargain. Now, let's say you would like to see if you can get probation. Let's say deferred probation or unadjudicated probation. And let's say you talk to the prosecutor said, no, I'm not going to offer you unadjudicated probation. I'm going to offer you jail time. You say, well, I don't want jail time. That basically says that you can change your mind and say, well, Judge, I want a court-appointed lawyer, a court-appointed attorney, okay? A court-appointed lawyer to represent you. You can do that. All right. Now, at the bottom of this document, everyone is going to make a choice. There are 5 lines to the left. If you would like to hire an attorney, you will place your initials on the first line to the left. Okay? So after you place your initials on the first line to the left, you will sign on the line that says defendant, you will date it, and then you will stop. And this will be the only form that you have to sign for those individuals who will be wanting that case to be reset to hire their own attorney. All right. If you've already hired an attorney to represent you, Then you'll place your initials on the second line to the left at the bottom. And then the name of the attorney will go on the line to the right on the second line. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom. You will sign and date it today's date, which is October the 14th. And then you will fill out the affidavit of indigence, the first page, as I mentioned to you. And then on the second page, you'll fill out the top portion that is titled Defendant's Oath. And then the bottom portion that's titled Unsworn Declaration by Defendant. And then you'll stop. Now, for those individuals who will be waiving their right to an attorney and they will be desiring to represent themselves, you would have to place your initials on the fifth line, which is the last line at the bottom to the left. Place your initials there. Sign the line that says defendant and date today's date, October 14th of 2025. And then you would have to read and sign this document that is titled Waiver of Counsel. Yes, read and sign that waiver of counsel, and then you'll stop. All right. Do we have any questions? All right. Now we're going to give you time to fill out the paperwork. I just need to go over some more rights that you have. Now you can enter one of three types of pleas. A plea is you can enter a plea of not guilty. If you're in a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Okay? Now, if you enter a plea of not guilty, you're telling the court that basically you're not guilty of these charges and you would like that you have a right to have a trial by jury. Okay? Now, that area over there where those 12 chairs are, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state and the defense, and they will also listen to the arguments of the state and the defense, and they will go into that back room, we call it the jury room, to deliberate, to decide whether to find you either not guilty or guilty of the charges. Now, you can waive or give up your right to have a trial by jury. And what that means is if you waive or give up your right to have a trial by jury, you will not be having a trial by jury. Now, if you still want to have a trial, you can have what is called a bench trial. A bench trial is a trial by judge only. The judge sits on the bench. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence that's presented by the state and the defense. The judge will apply the facts to the law, and then the judge will decide whether to find you either not guilty or guilty of the offense. Now, if you would like to enter a plea of guilty and no contest, and you would like to see if you can work out a plea bargain with the state, there are 2 types of plea bargain. One type of plea bargain is called an agreed plea bargain. The other type is called unagreed plea bargain. I'll explain the difference between the two. With the agreed plea bargain, that means that you and the state have reached an agreement to settle your case. Okay? Now, once you reach a plea bargain agreement, the case will go before the judge. And the judge can do one of 2 things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge rejects your plea bargain agreement that you made with the state, so for example, let's say you talk to the state, you want deferred probation or unadjudicated probation, and they offer to give you unadjudicated probation, you say, fine, that's what I want. It goes before the judge, and just say, well, I'm not going to accept that plea bargain agreement. If the judge does that, then you have a right to withdraw your plea, which means to take back your plea. So for example, judge is not going to follow the plea bargain agreement. He objects it. You say, well, judge, since you're not following the plea bargain agreement, I take my plea bargain. I take my plea of no contest or guilty back. I'm not pleading guilty and I'm not pleading no contest. You have a right to do that. All right. Now, if the judge follows the plea bargain agreement, then if you decided that you would like to appeal your case, then you have to get permission from the judge. And the judge can, if the judge gives you permission to appeal your case, then your case will leave this court. It will no longer be in this court. It will go to the Ninth Court of Appeals, which is right upstairs above us on the 3rd floor. There are 4 judges up there that will review your case. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than them. You can appeal it to the highest criminal court in the state of Texas, which is located in Austin, Texas, and is called the Texas Court of Criminal Appeals. You have to file what is called a pro se petition for discretionary review. I'll explain what that means. Pro se petition, pro se means you represent yourself. Okay. So you will be petitioning or asking the Texas Court of Criminal Appeals to review your case to see whether or not that appeal should have been granted or whether or not this court committed an error by convicting you. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition, at that point, then your conviction will stand. Now, let's say you and the state have talked and y'all can't come to an agreement, but you still want to enter a plea of guilty and no contest. We call that an unagreed plea bargain. So the judge will decide what your punishment will be. Anywhere within the punishment range, anywhere from deferred probation, unadjudicated probation, a fine, jail time, fine and jail time, or regular probation. So the judge has the full range of punishment to decide. Okay, that's called an unagreed plea bargain. Now, you also have a right to have witnesses that come to court. They sit in that chair that has the microphone in front of it. We call that the witness stand. And what witnesses do, they can testify. They can testify for you or against you. You're representing yourself, you can ask some questions. You have an attorney representing you, attorney can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses. That means you can give up your right to have witnesses. Now, if you do not call witnesses, or if you waive your right to call witnesses, that does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. The Fifth Amendment of the United States Constitution gives us a right not to incriminate ourselves, not to testify against ourselves. That simply means that the state, the district attorneys, or the government cannot force you to take the witness stand. They can't call you as a witness in your case. Okay? I know a lot of times we watch television. We see shows like Law and Order, and we see the television lawyer go up to the witness stand and ask the witness a question, and the witness say, "I take the fifth." What that means is I'm exercising my Fifth Amendment right against self-incrimination, and I'm not saying anything. I have a right not to say anything. I'm not going to say anything. And I always tell people this: it really makes sense that we have that right, because the state has the burden of proof. They have to prove you guilty. You don't have to prove yourself guilty. That makes sense. For you to prove yourself guilty, that's their burden, not yours. So we have that Fifth Amendment right against self-incrimination. Now, we also have a right it's called discovery. Discovery means we have the right to see the evidence that the state has and will be using against us. Okay, we have a right to see it or discover what the state has. And so we have a right to see witness statements, our statements, police reports, lab reports. We have a right to see photos, video recordings, listen to audio recordings, see documents, instruments, whatever they have, whatever evidence that they have that they'll be using against us. We have a right to have access to that. Now, you can waive or give up your right if you choose to, and if you waive or give up your right, then you will not be having access to the evidence that the state has against you. All right. Now, everyone that's here today, you've been charges have been filed on you, you've been arrested, placed into jail. You out of jail on bond. You're either out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on a PR bond, which means that you didn't have to pay any money to get out of jail. You were just released under your own personal recognizance. Now, I say that to say this. Every day that you spent in jail can be used as credit toward your punishment. Now, the operative word that I used there is every day. Now, let's say last night you were booked into jail at 11:59 p.m. last night. And then you booked out of jail 2 minutes later at 12:01 a.m. Okay? That's 2 minutes, but you get credit for 2 days. Why? Because it's 2 different days. All right? So every day that you spent in jail, you get credit for the time that you spent in jail. So for example, let's say you spent 5 days in jail, and let's say the state is offering that you serve 5 days in jail. That means that you will not have to serve any more time in jail because the time that you spent in jail has already, you can get, we call it credit, you get credit for time served. So you won't have to spend any more time in jail. Now, if the state is offering 7 days in jail and you spend 5 days in jail, that means you would have to spend 2 days in jail because we subtract 5 from the 7 and that leaves 2. All right. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You are credited $100 for every day that you spend in jail. So if you spend 5 days in jail, that's $500 that can go toward your fine and court costs. So the state is offering you fine and court costs of $500. That means you won't have to pay it. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, it'll be taxed and retired. Now, if they're offering fine and court costs of $700 and you have credit for $500, that means you will only have to pay 2 because we'll subtract 500 from the 700 and that leaves 200. Now, you'll be required to pay the fine and court costs on the day that your case is disposed of. Now, if you cannot pay it, no problem, because we can put you on what is called a payment plan. And if we put you on a payment plan, you'll be paying the fine, the remaining balance of $200 in small monthly installments until it's paid off. Now, if you do not have the income to pay off a payment plan, no problem, because we can convert your fine and court costs to what is called community service. So every 1 hour that you perform at a nonprofit organization, $12.50 will go toward payment of your fine and court costs. So for example, if you work 8 hours of community service, that's $100 that will go toward your fine and court costs. So in our scenario, if you work 2 8-hour days, that's $200. And so it'll be paid off. All right. Now, Jefferson County has a program for people who haven't been in trouble before. If you, well, I say trouble, if you haven't had cases filed on you before your first time, then Jefferson County District Attorney's Office has a program that is called pretrial diversion. With pretrial diversion, they will dismiss your case and you could get it wiped off your record like it never happened. Okay, in order to qualify, 3 things has to happen. 1, it has to be your first time having cases filed against you. And then 2, You cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And three, you have to have an attorney to assist you with the application process. That attorney could be a court-appointed attorney. You don't have to just necessarily hire an attorney. Now, if those three things happen, case will be dismissed. And once you complete the program, then you can get it expunged, deleted, wiped off, or erased from your record like it never happened. All right. The next thing is, if you're a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It's for veterans only. And with the Veterans Court, what they will do, you get into the program and complete the program, and you dismiss the case. And then you can get a non-disclosure whereby your record is sealed to the general public. Now, this court, County Court at Law Number 2 of Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office. The program is called the CSI program, or the Community Safety Initiative. With that program is designed to address the issue of what we call recidivism. Recidivism just means how people commit crimes over and over. And so how do we address it? Well, we address it through the Community Safety Initiative. And with the Community Safety Initiative, we have partnerships with various agencies in our community. They'll come to you in a few minutes and tell you a little bit more about the programs that they have to offer. But we have a partnership with Spindletop. Spindletop is our local mental health agency in the Southeast Texas region. Spindletop has expertise to address mental health needs or mental health issues that a person may have. Now, to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the ability to address those issues. Now, basically what Spindletop can do today is they can conduct a private interview, either in our jury room, at their facility, by telephone, or whichever is convenient for you. They have the ability to do what is called an assessment to determine what your mental health issue may be. And they have the ability to develop a treatment plan for either outpatient or inpatient treatment to address your mental health needs. Now, if you have issues with drugs and alcohol, well, Spindletop has a recovery program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And basically what they would do, they can do a screening, then they can do an assessment to determine what your issue may be with alcohol or drugs or both. And then they can develop a treatment plan to address your issue that you may have with alcohol or treatment or both. Now, if you are unemployed, do not have a job, or you're looking for a better job, well, we have a partnership with our Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school or you do not have a GED, well, CIC also has a GED program where you can receive your graduate equivalency diploma. All of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this school, we don't just give time, we take our time. It simply means that we do not just arrest the problem, we address the problem. And if we believe that, if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we don't have court as usual. We have unusual court. And it's not because we are different, but we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community because what comes out of the home goes into the community. And so if you're interested, just let us know so we can get you on the road to you living your best life. So as I mentioned to you earlier, we have some people that we have partnerships with. They're going to come to us and tell you a little bit more about the program. First, we're going to start off with a spindle top. We have Caitlin, Deputy Neville. Oh, Powell is here. Okay. Deputy Powell.
If we look too much alike, I'm getting that a lot.
Okay.
You can fire him.
Okay. Okay, we have Deputy, I'm gonna have Deputy Powell, and we have Kate from the spindle top.
How y'all doing? Very important. Hey, everything's gonna get all right. So my name is Deputy Powell, but it's still not. The history about it, long ago, the place where the gym was gonna help you. And, you know, a lot of people got hurt, the ops got hurt, the victim got hurt. And now we team up with mental health professionals like Ms. Guillory here, that, you know, we try to get out, talk with you, try to keep you out of jail, try to keep you out of the hospitals. You know, try to get every opportunity there is out there for you, you know. You know, so Ms. Guillory's gonna throw that little piece of paper on there. It's optional, so just listen to what she has to offer.
So there should be like a half sheet of paper somewhere on your clipboard. It's a really small piece of paper like that one that he's holding up. How to fill that paper out is pretty much self-explanatory. The bottom under the bold line, you leave that blank that is for me. So if you were to check mental health, which could be depression, anxiety, or PTSD, or substance use, which could be any type of drugs or alcohol, what we offer is spinal tap services or to get you in contact with other services in the area to help you with that resource. So what spinal tap offers for mental health is talking to a doctor to get medication, if you're interested in that, talking to a counselor, talking to a therapist, getting a diagnosis. And for substance use, we have support groups and support classes that you can attend. Like he said earlier, this is optional. You do not have to fill this paper out. If you don't fill it out, you can still turn it in blank because you can always use the blank paper. If you'd like to talk about spinal tap services or any services in general with me in person today, please write on your paper, please talk to me today. And then when the judge is done with you, I'll come and get you, pull you to a back room and we can talk privately. Everything that you tell me is protected by HIPAA. I don't tell the judge, I don't tell anybody else in the courts. It's between me and you and whoever else you allow the information to be shared with. Okay? Do you have any questions? Anything to ask for your time? Okay.
Okay, at this time, ladies and gentlemen, we have Johnny Stewart. He's with our family services. If you have a case involving assault, family violence, then he can tell you about a program that is called BIP, Battles Intervention and Prevention Program. If you able to get in that program, it will dismiss your case and you can get it expunged or wiped off your record. At this time, we have Mr. Johnny Stewart.
Okay, thank you, Judge.
Okay.
Good morning. I'm Johnny Stewart. I'm the BIP Director, Batteries Intervention and Prevention Program. Used to be called the Domestic Violence Program, Family Violence Program. The program that we're talking about is a 18-week program. It will once a week, 2-hour classes. It will assist you in changing some of those behaviors. I love the part where the judge says we don't arrest the problem, we address the problem. We're addressing some of the violent behaviors that you have. And we want to see those changes in you after the 18 weeks. And it won't do any good. I tell people it won't do any good to put you in jail and not address those issues. So the batteries program is about addressing those issues concerning intimate partners, family violence. And we want to see you change those behaviors so you won't end up back here in the court. We have some brochures over there. If you're interested in the program, I suggest you take advantage of this program because it's not going to only help you, it's going to help your families, it's going to help others. So really encourage you to consider that program if it's your first time with a family violence charge. Thank you for your attention. I appreciate it. Thank you, Judge.
Okay, thank you, Mr. Stewart. And ladies and gentlemen, next we have Mr. David Cook. He's with Texas Care. He'll tell you more about the program at Texas Care. That's all.
Thank you. Good morning. My name is David Cook. I'm a mental health peer support specialist. I'm kind of the living proof that these services can change your life. I was diagnosed a couple of years back with PTSD, bipolar. Going through a pretty hard time with sitting in rooms like this, you know. And I was able to utilize the community resources that were offered and use them to my advantage. So it's just cool to be a part of a system that is actually trying to help. And so anyway, I work for Texas Care, I work alongside Middletop. They have great services they provide. And we mostly focus on children, any behavioral issues that children might be having. We mostly take Medicaid and other private insurances. But we have like mobile QMHPs that actually go visit the children at school or visit them wherever they might want to, in their house, could be in a park, you know, it kind of makes it up a little bit. And it's been super, it's been helping a lot in the community. So we also offer crisis intervention, skills training and development, targeted case management, and evaluations and assessments. But I'm just super grateful to be here and to you know, actually be the example for that, you know, that things can change. And you know, if you have any questions, also have a piece of paper on your clipboard towards the back, and I'll be here for a little bit, but I will get back with everybody with me. Appreciate it. So I'm gonna pick up.
Okay, thanks a lot, Mr. Cook. Okay, ladies and gentlemen, we're gonna give you time to fill out the paperwork. If you have any questions, just let us know. We have our court personnel who's here, including myself, who will be happy to assist you with filling out the paperwork. Now, once you fill out the paperwork, what we're gonna do, we're gonna call you before the bench one at a time. And we're gonna put you in one of three categories. Either you want to hire an attorney, you want to apply for court-appointed attorney, or you would like to represent yourself. Okay, now, if you would like to have your case reset to hire your attorney, your case will be reset today to give you time to hire your attorney. If you would like to apply for a court-appointed attorney, if you qualify, you will be appointed an attorney before you leave here today. If you would like to waive your right to attorney and represent yourself, then at that point, you'll have an opportunity to talk to the state prosecutors, see if you can work out a plea bargain agreement, whatever, and that case will be taken care of today. All right? Now, it's gonna take us a little time to pick up the paperwork from you. And so if you need to use the restroom, there are two restrooms right outside in the hall. You have the men's restroom in front of County Court at Law number 3, and then on the opposite side of the hall, you have the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom. And then, you come back in the courtroom. Please do not leave the courthouse. If you leave the courthouse, and then your name is called when we call your case and you're not here, your bond will be forfeited. Warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail, and of course, you'll bond out of jail again. And guess what? We'll have to go through this all over again. So, to avoid that, this is gonna take us a couple of minutes to get everything done to get you in and out. All right? Now, please conduct yourself accordingly because we're still in court. Do we have any questions before the court goes into recess? Any questions? Okay. All right, the court is in recess.
Make sure you complete your paperwork before you step outside, if not, you will prolong the process. There you go. If you that, I can collect your paperwork.
Jefferson County Court at Law number 2 is back in session. The court is in session, back in session with its arraignment docket. When I call your name, please come forward before the bench. Deron Dwight Patterson. Mr. Patterson, your full name is Dwight Patterson. You say it's Darren? Okay. Mr. Patterson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Patterson, you may put your hand down. How are you doing, Mr. Patterson? That's good. Now, Mr. Patterson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Let's speak up.
Yes, sir.
Okay, now, Mr. Patterson, before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Patterson, your case is going to be reset to give you opportunity to hire an attorney. Just have a seat in that first chair and wait for your name to be called. Once your name is called, you'll get your reset and you'll be free to go, and you have a blessed day.
Regular resets on them, right? Mr. Rangley? The two guys on Zoom?
Well, they have to come back in and sign the paperwork. Hold on a minute. Okay, now, Mr. Collier, you have two cases. And you were appointed an attorney by the name of Ryan Matuska. Okay, okay. Uh, So we kind of figured that. And so what we're going to do is going to give you your reset. And Mr. Matuska will be given information to contact you, and you'll be given information to contact him. Once you get that information, you'll be free to go and you have a blessed day. Have a seat in that first chair on the wall. Ebony Chapman. Ms. Chapman. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Chapman, you may put your hand down. How are you doing, Ms. Chapman?
Fine, and you?
I'm doing fine, thanks for asking. Ms. Chapman, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Ms. Chapman, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Ms. Chapman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you. And you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Have a seat in that second chair on the wall.
Thank you.
You're welcome. That's the guy, he already had, Ryan Matuska. That's the lady that just.
Did she give you,
Mm.
okay, just leaving. Huh? Thank you.
Okay. Mr. Elias, on Zoom. Okay, Mr. Elias, your case has been reset till October 28th, 2025 for your initial appearance at 9 AM. You have to be in court on that day. I think you stated that you talked to attorney Jared Gilthorpe. If you hire Jared Gilthorpe before that date, then he'll reset your case.
Okay.
Okay, so it's at October 28th, 2025 at 9 AM in County Court at Law Number 2 of Jefferson County, Texas. Now you're free to go and you have a blessed day.
I appreciate it, sir. I had a quick question before. Is there any way I could apply for a court appointment?
You have to be here in person.
Okay.
You could do that
Yeah.
on that date.
Got you, sir. All right.
Okay.
Appreciate it.
All right, you're welcome. Okay, Mr. Tyler Gobar. You take your mic off of mute. Now, Mr.
Yes,
Gobar,
sir.
your case has been reset to October 28th, 2025 at 9 AM. On that day, you need to be in court in person.
Yes, sir. October 28th, 9 a.m.
Yes, October 28th at 9 AM, County Court at Law Number 2, Jefferson County, Texas. All
Okay.
right, so you're free to go and you have a blessed day.
Thank you.
Astrid Jones. Ms. Jones, your full name is that Astrid C. Jones?
Renee,
Astrid.
R,
Okay, there's a C, there was a C on this document. So it's Astrid Jones?
Astrid Renee Jones.
Okay, how are you doing?
I'm fine.
That's good. Now, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, you may put your hand down. How are you doing? That's good. Now, Ms. Jones, I have before me two documents. First document is titled Judge's Explanation of Rights for Defendants Without Attorney. You recognize this document?
Yes, sir.
On the next document, this document is titled Jefferson County, Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature at the top above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now I'm gonna go back to the first document. On this first document, there's a signature on the line that's titled Defendant. Is this your signature?
Yes.
And there's a set of initials on the third line that state you would like to hire a court appointed, that you would like to have an attorney appointed to represent you.
Yes, sir.
Okay, now, Ms. Jones, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Jones, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
You're welcome. think they may have a dismissal.
Yeah, I have some.
I don't know. I don't know.
Anthony Chapman? No. Should sort of come to furniture for your house. Now it's located in December 3rd at 9 p.m. and you should put her information down. Okay. Thank you, I'm almost getting out of this program. I'm gonna show you. I just got
What you looking for?
Well,
Who hired who?
yeah, that's how we did it. Yeah, that's what I'm, yeah. But obviously he didn't follow the letter, they haven't received it yet. Right. So tell him to put on his, judges, that's letter that he had.
That's the second box. He would,
Yeah, that's.
the second line, you put initials on the second line and then in the name of the attorney in the,
He says.
to the right.
Well, about him, let me get out of here. Just get rid of him. Are you printing? No, you need to. Oh, no, good. Okay. That's all you're gonna give me. You said we. You sure this something that we heard, right?
I don't know who hired right.
The name I just gave you. Oh,
You don't remember.
Carter.
Quarters.
He's outside. He had just got here.
Okay.
Wiseman called him earlier and told him to be.
Okay, I'm gonna give him some bond conditions too. Just send it to me. Bernice Williams. Mr. Williams, your full name is Bernice Williams?
Curtis.
Curtis?
Yes.
Okay. Mr. Williams, how are you doing? That's good. Now, Mr. Williams, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine, thanks for asking. Now, Ms. Simmons, I have before me a motion to dismiss.
That's correct, Your Honor.
Okay. Mr. Williams, I'm signing this motion to dismiss. You'll be able to get a copy of this motion in a few minutes. You'll be able to get a copy of the motion and the order to dismiss. You can have a seat in that second chair and wait for your name to be called. Yeah, I just signed it. That's the same thing on Bob.
That one has a plea as well as.
Oh, okay.
Your Honor.
I haven't typed it up.
Very well.
Okay.
Very well.
Yeah.
Here it is.
Were you calling Bond now?
Hmm?
Were you calling Bond now? I don't know if that's what you're just calling.
No, she didn't, yeah, well, no, I'm not ready on bond because she has to do there's a plea along with it. Bernal, well, let me do these other folks, that will get them out of here. Erica D.
Right. No, you don't have to have like Gracie said, you can go.
That's it. Okay, Packer, who's second had Ebenezer chapter. Oh, no, second chapter. Okay. This is cause number 25 CCCR 1966. The case is style of State of Texas versus Erica R. D. Ms. D, is that your full name?
Yeah.
Ms. D, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. D, you may put your hand down. How are you doing, Ms. D? That's good, Ms. D. I have before me two documents. First document is titled Mr. Okay. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And at the bottom of this document, there's a signature on the line that's titled Defendant. Is this your signature? And are these your initials on the line that state you like to apply for court appointed attorney?
Yes, sir.
I have another document that is titled Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. D, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. D, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. Shedrick Matthews. Right. Mr. Matthews. Your full name is Shedrick Dwayne Matthews? Okay, Mr. Matthews, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Matthews, you may put your hand down. How are you doing, Mr. Matthews? That's good. Now, Mr. Matthews, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Matthews, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Matthews, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nicholas Jeter. Attorney Jeter will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
You're welcome.
I just heard you gonna print it. Okay. Okay. Erica D.
That was the guy we just dismissed. They just dismissed that case. Ooh, I didn't have it. Signatures. I'll do this here. So you're Mr. Bond. Let's see. This is. Now, Mr. Bond, I have before me two cases. They are cause numbers 25 CCCR 1078 and cause number 25 CCCR 0362. Right. And your full name is Kevin David Bond, is
Yes,
that
sir.
correct?
Yes.
Mr. Bond, would you please raise your right hand? Mr. Bond, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bond, you may put your hand down. How are you doing, Mr. Bond?
Pretty good.
That's good. Mr. Bond, I have before me two documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your rights to an attorney
Yes, sir.
and represent yourself? I have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Okay. Yes. Mr. Bond, I also have another document on my computer that is titled Information. This document was filed by the Jefferson County District Attorney's Office. In this document, it alleges that you, Kevin David Bond, on or about July 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving with license suspended with previous convictions. Now, Mr. Bond, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead guilty, not guilty, and no contest?
No.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Bond, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are 2 sets of initials. First set of initials is below a paragraph that's titled waiver, and it's next to a box that's checked guilty. Did you place your initials KB on this document?
Yes, sir.
The next set of initials is below a paragraph that is titled discovery admonishment, and is next to a statement that state, I do not request discovery in this case. I waive my right to discovery
Yes.
and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above a line that is titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Bond, before you signed and initialed all of the documents that I just showed you, did you read the documents? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bond, are you a citizen of the United States?
Yes, ma'am. Yes, sir.
Say after states one.
Okay. Mr. Bond, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. Now, State's Exhibit number 1 is the first document that I showed you on this tablet. And the document that you acknowledged is State's Exhibit number 1, misdemeanor plea admonishments. This is the same document that you acknowledged that these were your signatures, your initials. And this is the same document that has your signature on page 3.
Yes, sir.
Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit number 1 is admitted. Mr. Bond, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Bond, I will accept your plea of no contest.
That's a plea of guilty.
Your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
State's asking for a $500 fine plus court cost, and we are asking the court to assess the 29 days jail credit towards both fine and court cost. And we have agreed to dismiss the companion criminal trespass, Your Honor.
Okay. So the fine is 0?
Yes, Your Honor.
Okay.
The court cost should be as well.
Okay. 0 plus. What's the court cost in this case? No, the fine is $500.
Yes, Your Honor.
And what's the court cost? 277. 277. That's the 777.
Total is 837.
So this is 337 court costs. Okay. So, Mr. And then there's,
29 days credit, Your Honor.
29 days credit toward the final court cost. So the court cost actually is taxed and retired. Okay, now, Mr. Bond, the state is offering that you, sir, that you pay $500 fine plus court costs, $337. You will be given 29 days credit toward the fine and court costs, which means it'll satisfy the fine and court costs.
Yes.
And so, Mr. Bond, do you understand the state's offer?
Yes, sir.
Do you think that is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
And the state will be dismissing cause number 25 CCCR 1078
Yes,
as part of this plea bargaining agreement.
yes, sir.
Okay? Now, Mr. Bond, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you're free to go, and you have a blessed day.
Thank you.
You're welcome.
Okay. You said you didn't sign his dismissal.
Oh, not yet. You could just hold on, I'll just sign this, to be able to get a copy.
This is needs to be better, correct? Okay. This is Bryce Klein, Judge.
Okay. All right, just printed it. I just signed the dismissal. This is his paperwork. What is this? I don't know what this is. This was a reset. The Ron Patterson, he was the first case. Jesse Tyler Bernal.
Get ready to print.
Oh, that door is locked, sir. Oh, it's open? Okay. Okay, Mr. Bernal, before we get started, need to inform you that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right? Okay, Mr. Bernal, Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Bernal, you may put your hand down. How are you doing, Mr. Bernal?
I'm alive.
Well, that's good.
Mhm.
It's better than alternative.
Yeah, I agree.
Now, Ms. Bernal, the state is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor.
That's good. Now, Mr. Bernal, I have before me on paper a document. I have two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of entering guilty plea proceeding trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Bernal, before you sign and initial these documents, did you read the documents?
Yes,
Did you understand what you read?
yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bernal, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jesse Tyler Bernal, on or about June 13 of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault, family violence. Mr. Bernal, do you understand what you have been charged with?
Yes,
To this charge, how do you plead guilty, not guilty, or no contest?
sir. Okay.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes. Yes, sir.
Mr. Bernal, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials is below a paragraph that's titled Waiver, and these initials are on a line next to a box that's checked no look at tendre, which means no contest. Did you place your initials on this line?
Yes, sir.
Second set of initials is below a paragraph that is titled Discovery Admonishment, and they're on a line next to a statement that state, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty, no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Bernal, before you signed and initialed all of these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bernal, are you a citizen of the United States?
State offer States Exhibit 1.
Mr. Bernal, the state is offering State's Exhibit Number 1 to be used as evidence against your State's Exhibit Number 1 is the first document that I showed you on the tablet. This is the same document that have your initials on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objections. State's Exhibit Number 1 will be admitted. Mr. Bernal, is there any evidence that you are currently mentally incompetent to stand trial? There's none.
Yes, sir.
Mr. Bernal, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication
with a fine of $250, repayment of court costs, 24 hours of community service, and successful completion of an anger management program. And Mr. Bernal has credit for 1 day of jail time to go towards his fine and court costs.
Okay. 1 day. Yeah, it is 1 day credit.
Was it on?
Yes, on there.
Oh.
So, let's see, that's 100 crime victims. 250, what's the court cost?
270.
277. Okay. Oops. Would it be 100, let it be 150. Okay. Okay. Mr. Bernal, the state is offering that you serve. Hold on a minute. What did I write? Oh, I put it in my spot here. 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $250. You will also be required to pay court costs of $277. You'll be given 1 day credit that will go towards your fine and court costs. So instead of the fine and court costs being $527, it'll be $427. Okay? Because it's 1 day credit, that's $100.
Right.
Okay. You'll also be required to pay $100 to a family violence center in the Jefferson County area. You'll also be required to pay probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $131 a month. Will you be able to pay the $131 a month? No, it's not, whether you can or cannot, it won't change the agreement that you made with the state. If you can, fine. If you can't, I just need to know.
No.
Okay. Do we have is that affidavit on? Hold on a minute. Let me see if I can see one in here. I'm gonna look in your file. I don't see I don't see. I don't see it in here.
Oh, yeah, yeah. They answered the job.
I don't see, they didn't put it in this file.
How about that?
Yeah, is it sometimes, let me see if it's, maybe see it, sometimes they misfile it. No, that's not it. And shoot. Let me, okay, because I only see a few. Initial appearance, I see the personal bond. That's correct. They put the bond in there, but they didn't put the.
How long ago?
It was, September 9th. Maybe they hadn't,
Yeah, that's where I had to go to the room and I had to speak to the
Yeah.
PI judge. and
Yeah.
He asked me, he was like, "Are you working right now, Mr. Bernal?" I said, "No, sir, I
yeah,
attend to my grandmother up in Woodville." And that was.
okay, okay. Good,
Did he get arrested in another county?
I'm sorry,
where did you get arrested in another county or it was Jefferson County?
here in Groves.
Okay, so it was,
So he just asked you, you didn't do a form?
he probably got magistrated at the jail,
That's
cause
he
what he
said,
was
but-
saying, yeah.
Yeah, I didn't know if he did that.
Could we get a, affidavit?
And those were the only questions that he asked me. You know, asked me something like this had happened before, no. Asked
Right.
me if I had a job, told him no, asked me what I was doing currently.
Um,
And then I explained to him that I was in Woodville.
okay,
attending to
okay,
my
okay.
grandma. That was it.
Okay, she's gonna give you a, you know, that form that was on the clipboard that I mentioned, the affidavit of indigence. What you can do is just, fill out the financial portion, so I can review to make the determination whether or not you're indigent. It should, just get one of them clipboards in there in the, Okay. Mr. Bernal, I have before me a document that is titled Affidavit of Indigence. Do you recognize this document? Now, Mr. Bernal, is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Bernal, the court is going to find that you're indigent. Based on the finding of indigency, let's see. That's 1 year deferred adjudication. Now, you'll be required to pay a fine of $250 plus court costs of $277. You'll be given 1 day credit toward that. And because the court found that you are indigent, the fine and court costs will be converted to community service. It will be converted to 34 hours of community service. The probation fee in this case of $60 a month will be waived pursuant to Article 42A .652 of the Texas Code of Criminal Procedure, because the court has determined that the payment of the reimbursement fee would cause you to have a significant financial hardship. And the reimbursement fee of $15 in this case will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure, so you will not have to pay that. You will be required to pay $100 to a family violence center in Jefferson County. You will also be required to pay the urinalysis fee of $15 a month. So your total monthly installments, that is the total amount that you'll be required to pay each month, is $25 a month. Okay? You'll also be required to perform 24 hours of community service. Now, that's 24 hours is in addition to the 42 hours of community service, in addition to the 34 hours of community service, which comes to a total of 58 hours of community service. Okay? You will also be required to attend and complete an anger management class, and you'll be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Bernal, do you understand the state's offer and the findings that the court have made in this case?
Yes, sir.
Okay, Mr. Bernal, do you accept the state's offer?
Yes,
And
sir.
do you think that is fair and just?
Yes, sir.
Okay, Ms. Bernal, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Bernal, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure, okay? Now, Mr. Bernal, just have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll go to the table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. You're welcome. Sweet. Paul Jubert. Okay, Mr. Jubert, your full name is Paul A. Jubert Jr.? Mr. Jubert, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jubert, you may put your hand down. How are you doing, Mr. Jubert?
I'm doing good tonight.
That's good, Mr. Jubert. State is represented in this case by Mr. Samuel Masradian. Mr. Masradian, how you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Jubert, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. You waive or give up your right to have a court reporter?
Yes, sir.
Okay, Mr. Jubert, I have before me a document on paper that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And all these your initials on the line that states you'd like to waive your right to attorney and represent yourself?
Yes,
I
sir.
also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Jubert, I also have another document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Paul A. Jubert Jr., on or about March 25th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Jubert, do you understand what you've been charged with?
Yes, sir.
To this charge, Mr. Jubert, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Jubert, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of, 3 sets. He got this. Okay. He put his initials on both of the lines saying he want discovery and don't want discovery.
Apologies.
Yeah, he have to erase one of them. Okay, thank you.
Fine. No, it's fine.
Now, Mr. Jubert,
Yes, sir.
there are 2 sets of initials on page 2. First set of initials is below a paragraph that is titled waiver, seconds, and they're on a line next to a box that's checked guilty. You place your initials in this location.
Yes, sir.
Second set of initials is below a paragraph that is titled discovery admonishment, and these initials are on a line next to a statement that says,
Yes.
I do not request discovery. I waive my right to discover in this case and choose to enter a plea of guilty and no contest. Place your initials in this location.
Yes,
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
At the
sir.
top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
Now, Mr. Jubert, before you signed and initialed all of the documents that I showed you,
Yes, sir.
did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State. Well, Mr. Jubert, are you a citizen of the United States?
Yes, sir.
State offer states 1, Your Honor.
Now, Mr. Jubert, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on the tablet. This is the same document that have your initials on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Mr. Jubert, is there any evidence that you are currently mentally incompetent to stand trial?
Yes. No, sir. No, sir.
Okay, Mr. Jubert, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Be 180 days county jail, probated for a period of 15 months, with a $500 fine, 60 hours community service, and he has 2 days credit to go towards fine and court costs.
2 days. Oh, he didn't write it on this one.
I
You
did.
need to, put 2 days credit on
On
here.
that top area.
Yeah, where it says credit, right there. Okay, thank you. Oh, okay, this is just 5. What is this court cost?
277.
277?
It's 2 hours.
Oh, that's 2 days toward that.
Yeah, no, most definitely. I was actually thinking about it. My 2 days, I was in this.
I saw it. I should get it.
Yeah, okay, all right. This is my first year.
Okay.
There we go. Let me see.
Okay, Mr. Jubert.
Yes, sir.
The state is offering that you serve 180 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation
Yes,
for a
sir.
period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $277, which comes to a total of comes to a total of $777. Now, you will be given 2 days credit toward your fine and court costs, so that will reduce your fine and court costs by $200.
Yes, sir.
So your fine and court costs total will be $577 instead of $777.
Yes, sir.
You will also be required to pay a probation fee of $6 a month, UNS fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $123 a month. Will you be able to pay the $123 a month?
Yes, sir. At the time, I am looking for a job, for right now. I'm just unemployed for right now.
Well,
Um,
do we have an affidavit on here? Hold on a minute. No, we don't have one in this file?
No, I already checked.
Okay. We need you to fill out that first page,
Yes, sir.
the financial information. Okay, now, Mr. Gilbert, I have before me a document that's titled affidavit of indigence. Do you recognize this document?
Yes, sir.
Now, before you filled out this document, did you read the documents? Did you understand everything that you read?
Yes,
Is
sir.
everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Gilbert, I read your answers. You meet the eligibility requirement. Well, to be found indigent. So, the state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve any time in Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you're required to pay a fine of $500 plus court costs of $277, which comes to a total of $777. You'll be given 2 days credit toward that, which will reduce it to $577. The $577 will be converted to 46 hours of community service pursuant to Article 42.15 Texas Code of Criminal Procedure. The probation fee in this case of $60 will be waived pursuant to Article, let's say 42A.652 of the Texas Code of Criminal Procedure, because the court has determined that the payment of reimbursement fee would cause you to have a significant financial hardship. And the reimbursement fee of $15 will be waived pursuant to Article 102.018 Texas Code of Criminal Procedure. You will be required to pay your analysis fee of $15 a month. Your total monthly installments in this case was $16 a month. Okay. Now, you'll also be required to perform 60 hours of community service. That's in addition to the 46, which comes to a total of 106 hours of community service. You'll also, let's see, be required to adhere to the other standard terms and condition of this probation. Mr. Juba, do you understand the state's offer?
Yes, sir.
You think the state's offer and the court's findings is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, Mr. Jewett, I'll follow the people in agreement that you have entered into with the state. Please have a seat in that first chair. Wait for your name to be called.
One of them back here, you can sign the last page.
That was Bernal. Leah Sanchez. Ms. Sanchez, this is cause number 25 CCCR 2024, case of style of state of Texas versus Leah Michelle Ray Sanchez. Ms. Sanchez, is that your full name?
Yes.
Ms. Sanchez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Ms. Sanchez, you may put your hand down. How are you doing, Ms. Sanchez? I'm doing fine. Thanks for asking. Ms. Sanchez, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Ms. Sanchez, I also have before me on my computer a document that is titled Information. Now, Ms. Sanchez, before we go any further, I must inform you that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay, Ms. Sanchez, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Leah Michelle Ray Sanchez, on or about July 21st of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Sanchez, do you understand what you've been charged with?
Yes, sir.
To this charge, Ms. Sanchez, how do you plead? Guilty, not guilty, and no contest?
No.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you do not wish to fight? I mean, are you pleading guilty because you are guilty? Ms. Sanchez, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials. The first set of initials below a paragraph that's titled waiver and is on a line next to boxes check guilty. Did you place your initials here? Second set of initials is below a paragraph that is titled discovery admonishment, and it is next to a statement that states, I do not request a discovery. I waive my right to discovery in this case and wish to enter a plea of guilty or no contest. Did you place your initials in the second location? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? On the next document that's titled trial court certification, the defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement? Second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Sanchez, before you sign and initial all of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Sanchez, I read your answers based on your answers.
State offer states 1, Your Honor.
Okay. Ms. Sanchez, the state is offering State's Exhibit Number 1 to be used as evidence in your case. Is it all right for the state to use this document as evidence in your case? Okay. No objection. State's Exhibit Number 1 will be admitted. Ms. Sanchez, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Sanchez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement? And what is the agreement?
State offering 1 year deferred, $200 fine, 24 hours community service.
What's the court cost? Okay. Ms. Sanchez, state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You're required to pay a fine of $200. plus court costs of $277, you'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $127 a month. Will you be able to pay the $127 each month? You will also be required to perform 24 hours of community service, and you're required to adhere to the other standard terms and conditions of this probation. Ms. Sanchez, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer? Now, Ms. Sanchez, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. Now, Ms. Sanchez, this will conclude your case. Please stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go, and you have a blessed day.
Thank you.
You're welcome. Roger Carter. Mr. Carter, your full name is, let's see, it's Roger Malloy Carter Jr.?
Yes, sir.
Okay, Mr. Carter, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Carter, you may put your hand down. How are you doing, Mr. Carter? That's good. Mr. Carter, I have before me a document that is titled Judge's Explanation of Right to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state that you've hired Ralph Kimmler to
Yes,
represent you? Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Carter, your case is going to be reset to give Mr. Kimmler an opportunity to send his letter of representation in, informing the court that he represents you. Now, before your case is reset, the bailiffs need to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Okay, now, Mr. Rogers, I'm getting ready to go over this document, which is state standard bond conditions in County Court at Law Number 2. And it states following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bill bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, defendants shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Now that condition doesn't apply because there's, victim in this case. And condition number 4 does not apply as well. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Carter, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Did we give him his reset?
No, we're getting it now.
Okay,
Can I ask a question?
okay.
Yeah, cause I ended up having a felony with this. I got convicted for the felony.
Okay, let me do this here. Let me just say, you have an attorney. I cannot answer any legal questions, or can't give you any advice or anything of that nature, you can talk to your attorney about it. Now, I would tell you this, that well, first of all, anything that you say can and will be used against you in a court of law. You have a right to have an attorney. You have already hired an attorney, so you can discuss that with your attorney.
Appreciate it.
All right, just have a seat in that first chair and wait for your name to be called.
We have any bond filters, Judge?
Let me see. Let's see. This will conclude the court's arraignment docket. The court trial docket will reconvene at 3 p.m.